Before we dive into understanding the definition of nuisance, it is essential to classify nuisance. There are two types of nuisance: public nuisance and private nuisance. Public nuisance is an unlawful act or omission which endangers the lives, safety, health, property, or comfort of the public, or by which the public are obstructed in the exercise or enjoyment of any right common to all. Causing public nuisance is a crime. There are different schools of thought for the classification of public nuisance. While it is a crime, some legal experts classify it as a tort too, and some experts believe that it is not a tort, merely a crime. However, the second group of people agree that should public nuisance cause a special injury to a particular person more than it causes to the others, such person can claim compensation in form of unliquidated damages. For example, blocking of a road for the purpose of a demonstration without the appropriate permissions is causing public nuisance. The blocking of such road will create traffic. Everyone is affected by such action. However, if there was an ambulance which was carrying a person who needed immediate assistance, failing which he would have lost the use of his left eye, and the blocked road causes him to lose the opportunity to seek medical assistance, such a person can sue the person blocking the road for unliquidated damages, seeing as he suffered special injury over what the others suffered. Blocking of a road, indecent behavior in the public, causing unpleasant or disgusting smells or loud screeching noises for a prolonged period of time, etc., are all examples of public nuisance. Private nuisance, unlike public nuisance, is undisputedly a tort. Private nuisance can be simply described as the causing of substantial and unreasonable interference with the use or enjoyment of the land of a person. Let's break this definition down to its components and get to the essential elements for nuisance. First, substantial interference, and second, unreasonable interference. Third, use or enjoyment of land of a person. The first element makes it essential for the interference to be actually substantial in nature. For minor annoyances, the tort of nuisance is not applicable. For example, a person cannot complain of the tort of nuisance merely because occasionally his neighbor burns the food she has been cooking and the putrid smell of burned food wafts into his room every once in a while. At the same time, he may complain if his neighbor smokes cigarettes and the smoke from such smoking enters into his home. The smoke from a cigarette is known to be harmful to a person, and therefore this would be seen as a substantial interference. The second element of nuisance is that any interference by the plaintiff must be unreasonable in nature. This means that there should be no lawful purpose for such interference. For example, a person cannot complain about the noise that a train causes when it passes close to his home. The annoyance caused by the passing of a train is protected, firstly, under act by statutory authority, and secondly, under the fact that the passing of a train is not unreasonable in any manner, whatever the time. The first and the second element are connected in the definition with the use of the word "and." This is because the interference should be both substantial and unreasonable. The third element of nuisance is that it should impede on the use or enjoyment of the land. Use or enjoyment of land shall mean actual use of land for the purpose of residing, construction, storage, or agriculture, or the enjoyment of land to sit in peace, or to use the land for dancing or listening to music or watching this video. Land means land, home, apartment, even a small space which is a part of a larger space. Use and enjoyment does not mean only use and enjoyment of a single person, but also any person or animal he or she allows into the land. For example, if your neighbor, for no justifiable reason, uses a whistle whose sound frequency is so high that only the dogs can hear it, and such a whistle annoys your dog constantly, you may successfully sue for nuisance. The tort of nuisance is a tort not against the owner of a land, but against the person who is at that time lawfully in possession of such land. To that end, a tort of nuisance can be filed against the owner of the property by the person who has possession of the property. In many torts, nuisance especially, there exists a concept of the overly sensitive plaintiff. For example, a person who cannot sleep in the presence of even the slightest light cannot complain that her neighbor keeps the light on into the night every night. This is because keeping a light on might be disturbing her. However, it is not unreasonable interference. She would be an overly sensitive plaintiff to whom the court cannot grant remedy in any form or damages.